All right, everyone, we're back for another installment of Kinesiology 3335, and today we'll be talking about employer liability for their employees' negligence. So this chapter is an extension and continuation of what you learned about in the chapter where we explored the concept of negligence. So because this chapter builds off of what we learned about previously, we're going to go through a little bit of review to try to jog your memory about what is negligence in terms of its relationship to employer liability for the acts of their employees through the legal concept of vicarious liability or respondeat superior. So remember, negligence is a type of tort. It is an unintentional tort where someone is held to a certain standard of a certain duty of care, and that person's conduct violates that duty of care, resulting in some sort of injury to another person. So here are the elements as a refresher for negligence: duty, breach, causation, and damages. So if you can recall back to the last class, duty of care is set up by society, either through statute or by someone volunteering to put themselves in a position where they have a duty of care to one person or another. And then also the relationship of the parties can create a duty of care, such as a coach and player, or as we saw in one example from a case, a university and student athletes. Just by virtue of the position of that the two parties have, certain rights and responsibilities flow from both sides, thus creating a duty of care. Now, there are some situations where no duty of care exists, such as if the one of the parties assumes the inherent risks of whatever activity that they're taking part in, or that they've signed a contract that operates as a waiver or somehow limits the liability of the party who allegedly breached their duty of care. But if there is a duty of care that's established, and they must abide by that duty of care, a breach might occur if that breaching party either does something that a reasonably prudent person would not have done, or does not do something that a reasonably prudent person would do. Either way, based on the standard of care that was created as a result of that duty, they've somehow breached that duty. They failed to act reasonably under the circumstances, and then a foreseeable risk of harm resulted. And if it's foreseeable, then it ends up being an unreasonable risk of harm, and they failed to abide by that standard of care. Such as a common example within sport or recreation is if there's a baseball diamond and there's stands around that baseball diamond, it would be reasonable if these people paid for the right to enter the facility and watch the game, that the most vulnerable areas of that baseball stadium where fly balls are most likely to occur or go into the stands, there would be some sort of mesh screening to protect the crowd from foreseeable risks of harm. And arguably a failure to put up that mesh screening could have been a situation where the owner or the employee failed to act reasonably and protect against the foreseeable risk of harm. And let's say that a projectile did go into the stands and someone was injured. Let's say they were hit in the head or they suffered some sort of injury. That would be damages, the final element, and some medical damage or some sort of other financial damage that they can attribute to the breach of the duty of care. And that would be causation. And causation is the direct line between the breach and the damage. So if duty, breach, causation, and damages are all met, then in theory negligence exists, and then it's up to the defendant to refute that. So if a prima facie case of negligence is proven, duty, breach, causation, and damages is proven, then the burden shifts to the defendant to put forth some sort of defense. So common defenses that were in the textbook are statute of limitations, meaning that the statute of limitations is a law that's on the books that says someone wanting to sue for a specific reason, whether it would be negligence or breach of contract, etc., has a certain time period to sue once they become aware that they have a claim. So once they've gained notice, then the clock is ticking. And oftentimes within the breach of contract, it's about 5 years, or it could be with a negligence claim, it could be 3 years. It differs from state to state depending on what's on the books. But if someone fails to bring a lawsuit during that running clock, if they are 1 day late, then the statute of limitations would bar them. And that would be a legally sufficient defense. Acts of God is a second type of defense, which is an unforeseeable natural disaster that somehow results in an injury to the plaintiff. If it's something that happens suddenly, like an earthquake or a thunderstorm that someone does not have notice of, something that occurs quickly is more likely to be deemed an act of God. And if it's out of the defendant's hands, because it was a natural occurring event, then it most likely is a valid defense. Contributory or comparative negligence on part of the plaintiff. We saw that in the last slide. That just basically means that if the plaintiff somehow committed their own negligence by acting unreasonably under the circumstances, or somehow did something to exacerbate the situation, that could be a way to apportion a percentage of fault. And under contributory negligence, usually at common law, any type of contributory negligence was a complete bar. And then comparative negligence is, remember, it's that amount that the court would assign a percentage of fault to each the plaintiff and the defendant. And the award would be reduced by the plaintiff's amount of fault. And then under modified comparative, if it's more than 50%, the plaintiff would lose their right to recover. Assumption of risk, again, is where the plaintiff understands and voluntarily agrees to accept the inherent risks of whatever activity they are engaging in. And even if they act reasonably, they consented to the logical consequences of their actions. So they need to understand and appreciate and voluntarily engage in that activity. Now, that could happen either verbally or non-verbally, so that's also something to keep aware of. And then finally, secondary assumption of the risk is where the plaintiff deliberately chooses to encounter a known risk, and in doing so acts unreasonably, such as failing to follow the safety rules. Let's say that someone was at the basketball court at a rec center, and an area was roped off because of some sort of condensation or water on the court, and there's wet floor signs, or do not use the basketball courts, and someone encounters that but still chooses to play basketball, ends up slipping and falling, then secondary assumption of risk, because they acted unreasonably and chose to encounter the risk, might be a potential complete bar as a defense. So it's important as sport managers or working in rec or working in athletics, it's important for anyone really to be able to identify risks within an organization. And that's really where that risk management or preventative law comes into effect, as we talked about in the early portions of this class. And just like identifying the risks that your organization subjects itself to, it's also important to identify the risks that might be present on the field of play, whether that's in a rec league or if it's in the facilities in which the organization operates or anything else. But critical awareness of what might be a breach of the duty of care could go a long way to addressing those risks through a proper managerial plan, a proper preventative law plan. But as always, going back to the beginning of the course in the first chapter, awareness of a risk or awareness of the law and what the law requires is the first step to creating a competitive advantage for both yourself and the organization. So that's very important. So now that we've done our review, and again, my door is always open, my email inbox is always open. If you have any questions about negligence basics, feel free to reach out. I'm here for you guys, and I want to make sure that things make sense. These are not easy concepts to understand. But if you do have a baseline understanding of negligence, then we can move forward to talking about employer liability for the actions of their employees, as well as other parties. However, if this is still a little bit hazy or funky, I would encourage you to pause this YouTube clip and go and either reread the textbook or look at a prior lecture or watch this lecture again up to this point, or reach out to me. Certainly there's also plenty of supplements on the web that can be helpful in explaining this as well. Okay, so for those of you who want to move ahead, we will move ahead. So in terms of employers' liability for their employees, this happens in a variety of managerial contexts, and there are different laws that govern an employer's standard of care for different types of situations that occur within the workplace. Now, of course, it should sound familiar and very reasonable that a sport manager or someone working in rec or in athletics must provide oversight of employees with at a reasonable level. There is a duty of care to provide reasonably competent oversight. So that also stems or flows to the hiring, supervision, and retention of employees, and also hiring independent contractors. And we'll talk about independent contractors later in this lecture. And of course, finally, the text talks about volunteers and college athletes, whether or not there's liability for organizations who either hire or work with them, and because they're not traditional employees. In fact, the court, in many cases, courts have ruled that college athletes are not employees, and that's a lecture for an entirely new chapter, which I think actually we'll get to later in this course. And also volunteers. They're not traditionally considered employees because there's not that sort of payment aspect, and there might be less control. But for the purpose of this chapter, oversight, hiring, supervision, and retention of employees are very important. But let's talk about tort liability for employers. So there are two very different ways for an employer to get in the hot water. And I guess this is a bad pun here. There is a direct way that the employer itself committed negligence by acting unreasonably under the circumstances or wrongfully. The employee or organization breached the duty of care that was established by society because its conduct fell below the standard of care. So some might be familiar with this example. In the 90s, there was a wave of lawsuits involving the fast food restaurant chain McDonald's, because McDonald's was serving customers coffee at a completely unreasonably high temperature. People would take the cup from the attendant, and it would be so hot they would drop it, and it would drop into the car, into their lap, and cause severe burns. Now, this was not an aberration, arguably. At the trial, the plaintiff's counsel introduced operations manuals from McDonald's showing that the established temperature of coffee for McDonald's restaurants should be at a very, very high temperature. I can't recall what it was, but it was vastly higher than what would a reasonably prudent organization would serve the coffee because of the risk of burning people. So because this was a policy in place, and that policy breached the duty of care to the employee and to the customers, and it wasn't just an employee messing up, because if it would have been the employee messing up, it could have been vicarious liability. But the actual wrongful conduct was created by the employer and carried out by the employees. Therefore, there was direct liability for negligence because people were injured as a direct result of the breach of the duty of care. The duty of care was established from customer or restaurant to customer, and it was to act reasonably and under the circumstances. The breach was that the coffee was the duty was to serve coffee as a reasonably prudent organization would serve coffee. And the breach was when it was served at such a high temperature that would burn you if you couldn't even grip it. And then that breach of the duty of care led to the damages because as a result of someone not being able to grasp the coffee because it was too hot, it spilled in the people's lap, resulted in medical injury, and that's a direct unbroken line between the breach and the damages, which is causation. So that's direct liability. Vicarious liability would be when the organization itself did not act unreasonably, but instead the employee of the organization acted unreasonably. And we've got a picture of Jerry Sandusky, the disgraced former assistant football coach who is now a convicted felon for the terrible acts that he was alleged to have done with children and preying on them through his foundation. So Penn State itself, as a football entity, did not commit these acts against the children or did not breach any duty of care. But because Sandusky was their employee, then not only was Sandusky liable, but also Penn State. And so this kind of will make more sense when we talk about this concept of vicarious reliability, or in Latin, respondeat superior, which means let the master respond. So this is a public policy rationale. Many of the laws in the books are intended to encourage society to act in a responsible manner. So this is a good social policy because we want, as a society, to have employers actively and closely supervise their employees. And it's easy to do that when that employee is spending great amounts of time working for the organization, and that supervisor should know what their employees are doing. So if the employer fails to be responsible for the acts of the employee because they're not abiding by their duty of care for supervision or proper training or properly screening them when they're hired, then the liability should also fall on the employer to deter them from making similar mistakes in the future and to also encourage society to act in a reasonable manner. This might also be considered a cost of doing business. But in order for vicarious liability to actually apply, that employee who commits a tort must have done so within what's called scope of their employment. And that just means that the employee is doing something to further his or her job with the organization or somehow benefit the organization. So for example, we've got the Smith versus Gardner case. And it's pretty short case, but you get what they're going for here. We get a baseball coach who is taking his team on a road trip to play a game. Drives the team using a university-owned van, and they get to the hotel. He drops everyone gets off and gets settled to the hotel, and then the coach goes and buys alcohol, comes back, starts drinking, gets drunk, and he wants to buy some chewing tobacco or maybe some tobacco or cigarettes. And he goes back out, and he goes into the convenience store and he buys this tobacco. On the way back, he gets into a car accident, and the person who he hit sued both both Gardner and the university. So the question becomes whether or not the university is liable for the tort of the employee due to respondeat superior, vicarious liability. And the court says emphatically, no, the university is not liable because the defendant was not at that point when the accident happened, was not somehow furthering his responsibilities with the university. He was not acting within the scope of his employment. Now, if the facts were a little bit different and the car accident occurred while the baseball team was driving to the hotel from the university, then that would be a different set of facts to look at, and it could potentially had been vicarious liability for the scope of his employment. But because what Gardner was doing was going out and getting tobacco after his obligations for the university had ended, it was considered a frolic and detour, and therefore it was not part of the scope of his employment, and therefore no liability for the institution. So things outside of your scope of employment are not going to fall under vicarious liability. However, and then the other exception would be intentional torts. If the defendant, the employee, committed assault or battery or false imprisonment, those things the employer is less able to control, and therefore it's not good public policy to make the organization responsible for that. However, there's an exception for sexual harassment because, again, going back to public policy, it is good public policy to make a inclusive environment where people do not feel threatened, do not feel unwelcomed at work, and because it's a good public policy to try to wipe out sexual harassment. The employer would be liable if sexual harassment was not going on, if sexual harassment was going on, and the employer didn't do anything to stop it. Because if the employer doesn't step in and rectify this, then the victim here could sue under the argument that the organization ratified, condoned, somehow embraced, endorsed the conduct of the offending employee. Therefore, the employer could still be liable under the legal argument of ratification. So, okay, now that we understand the basic concept of vicarious liability, its public policy rationale, how it works, and then exceptions to that, now we can get on to the three additional types of negligence in this chapter: negligent hiring, negligent supervision, and negligent retention. And then, having to deal with independent contractors, negligent selection of independent contractors. So negligent hiring, just briefly, is when a manager fails to act reasonably in choosing a specific person to hire. It's if the employer does not hire someone with the adequate skills, knowledge, and ability for that position. We'll talk about that. There was a popular example a few years ago when the University of Notre Dame football team or athletic director had hired George O'Leary, I believe his name was, as the head coach, only to find out that he had fabricated his resume. So that would have been a potential situation if they had never done any sort of investigation that would have shown that he was not qualified for the position that he claimed, but luckily Notre Dame did their homework. Okay, next we have negligent supervision. So negligent supervision is when a manager acts unreasonably in guiding and overseeing the day-to-day actions of their employees. So again, this is public policy rationale that the organization should be actively involved in supervising the employee, further developing the employee's skills through professional development, and otherwise being involved with the day-to-day of the employee. Again, it's good public policy. Finally, we've got negligent retention, where the manager somehow acted unreasonably in retaining the services of that employee. So the question becomes whether or not the organization is aware of the performance of the employee, whether or not the employee is meeting expectations, exceeding expectations, or failing them. Is the employee engaging in some sort of misdeeds, and the organization chooses to stand by and not punish the coach or the practitioner. So, of course, we see this example in the Mike Rice case, which we'll talk about shortly here. And this Venn diagram here shows that negligent hiring, supervision, and retention are all fairly interrelated in the sense that they all stem from negligence, that there is a duty of care that's owed by the organization to various parties to act as a reasonably and prudent organization in hiring, supervision, and retention, and to avoid foreseeable risks of harm. Now, what is a foreseeable risk of harm? It really would differ based on each of the circumstances, but for one, there needs to be an awareness of what are best practices or commonly held practices within the industry in which that organization operates. And if an organization fails to meet those basic tenets, then it could easily be established that that's a breach of duty of care. So if there's codes of conduct or rules or best practices that are created by different organizations, those would be good to look at. Certainly NCAA bylaws, those function as minimum baseline regulations that NCAA institutions must comply with. So again, going back to the different questions of law that each of these aspects brings up. Did the employer or manager breach the duty to hire safe and competent employees? Or did he or she fail to act with reasonable diligence? So the textbook gives an example of a Little League organization who hired someone to be in charge of facilities and then also have other roles with Little League, but they didn't do a background check. And if they would have done a background check, they would have uncovered that this person had been convicted in other jurisdictions of child abuse and sexual assault. And if they would have done that simple thing of doing a background check, which is very commonplace, they would have, that many organizations do, that they would have uncovered this. And so failure to act with reasonable diligence probably would be a breach of the duty of care. Negligent supervision. Did the employer or manager fail to act reasonably in guiding and overseeing the employee's actions? So we have, again, another great example of this through Mike Rice, the coach at the now disgraced coach from Rutgers, and who I showed the bit of video to illustrate negligence basics. So Coach Rice allegedly had been engaging in this series of behavior where he would be physically abusive, verbally abusive. He would with his players, and that although evidence of this behavior existed, the athletic director was put on notice by another staff member with the basketball team he was not able. He did not provide enough oversight to actually catch Rice in the act or correct this behavior by talking to him about it because he was aware. And then negligent retention, did the manager act reasonably in retaining the employee's services? So again, at one point in the video, it mentions that Mike Rice was suspended for a period of time, but it wasn't said as to why he was suspended. And so if you suspend him rather than firing him, again, that could be a breach of the duty of care. So with the Rice situation, it seems as though at least negligent supervision and negligent retention could be claims that someone who suffered an injury as a result of Rice's conduct, that could be actionable both against Rice and Rutgers, so long as you could establish a breach, an existence of a duty of care, a breach of that duty of care, causation due to that breach, and then injury. So this is why there are definitely teachable moments within this form. Or there was an example that was from about 6 years ago involving Mike Leach, who was the coach at Texas Tech at the time. And he had a player who he was either disciplining or trying to deal with some sort of corrective action, and he locked him in a tool shed and for a long period of time. And the athletics department and athletic director did gain awareness that Leach was doing this, and there was not any, even though there's awareness, there was no move to discipline him until it went public. So again, this could be potential teachable moments and examples of negligent retention. So there's many examples that exist in other areas of sport management, recreation management, facilities. And so, again, it's just, it's incumbent on us as future sport managers to understand how negligence works and how different aspects of negligence, hiring, supervision, retention, how they might affect the organization's liability, as well as the employee who committed these acts from a vicarious liability aspect. So, okay. We talked about negligence, and we've established it, how it works, and then how negligence hiring, supervision, retention work. But we also need to talk about independent contractors. Independent contractors are, it's a legal term of art, and we learned about this a little bit in the risk management and preventative law chapter, because independent contractors are often used as a way to counteract the potential liability that certain activities or practices carry. So independent contractors are people who are not employees. They are people from the outside who come in, and by virtue of a contract agreement between the organization that hires the independent contractors and the independent contractors themselves, they come in for a specific job with limited scope with a limited period of time. And they're deemed not to be employees, and therefore vicarious liability does not apply. So an employer is generally not liable for the negligent or intentional acts or omissions of the independent contractor. And this might be a situation where I showed you that video of CSC when they were doing crowd control at the University of Houston. CSC is an outside outfit that is independently contracted with between Houston and that organization to provide crowd control and security services, so that in the event that something does happen, let's say one of those fans who jumped down and is confronted by CSC is injured, or they're pepper sprayed, or they're tackled, the liability, if they are true independent contractors, would stay with CSC and not Houston, because Houston is not their employer. But as I said, there's general exceptions. And these general exceptions focus on control. The more control that the employer exerts over the independent contractor, the more likely the independent contractor then actually becomes an employee under the eyes of the law. So we look at how much control the employer has on the results of the independent contractor's work, or the amount of control that the employer has on the day-to-day activities and details of the independent contractor. So let's look at this as using certain examples. And actually, let's go to one more slide here because this is going to be helpful. Factors that determine independent contractor status are as follows: the right to control the manner in which the work is performed, the right to fire or discharge the independent contractor, the method of payment and whether taxes are deducted, the level of skill of the work performed, and the furnishing of tools, material, and equipment. So you're probably wondering what all that means. So let's look at the first one: right to control the manner in which the work is performed. That is asking how much control does the employer have on the day-to-day of the independent contractor. Is the employer overseeing the actions or work of the independent contractor, or is the employer saying, "Here, this is what I want you to do," and then the employer leaves the independent contractor alone? Traditionally, the more oversight or authority the employer has over the day-to-day and the work of the independent contractor, the more likely that independent contractor is actually treated like an employee. Because think about it. The employee generally reports to a boss or to the organization and takes the orders continuously from the employer. Right to discharge. If the independent contractor has an agreement with the organization that is just for that one transaction or a specific period of time, that makes it more likely that there'll be less control over the independent contractor, and shorter time duration means that they're not an employee. Therefore, in the converse, the longer the contract, the more likely it's an employee. Method of payment and whether taxes are deducted. If the person or organization that's hiring the independent contractor pays them on a bi-weekly basis and then takes out withholdings or taxes, that makes it more likely that they're an employee. But if the employer or organization pays the independent contractor a lump sum, or half not before and half after, and doesn't take out any money, it again helps to create the presumption that they're not employees. Level of skill and work performed. Independent contractors generally are perceived to be people who have specified skills or unique skills, and they're not generalists. So that's also a factor. And then whether or not there's an actual contract between the parties that has specific independent contractor language to establish a relationship as independent contractor is also important. So we look at the intent of the parties. So now contract law can also go into this, because contracts are just an agreement between two or more parties with rights and responsibilities flowing in both directions. So here is an example of a contract clause, or I'm sorry, here's an example of a contract with a clause showing that this is an independent contractor that's contracting with the organization. It says right in that heading, independent contractor relationship of the parties. The parties to this contract agree that the contractor is not subject to the company's control as to the means and methods of accomplishing the work to be performed. So that means that the contractor is not going to have the organization looking over their shoulder. So that means they're more likely to be independent contractors, and that the company may specify and control the result. So it needs to be to specific specifications or standards, but not controlling the day-to-day. The contractor selects his own employees. The contractor selects its own customers. The contractor provides their own tools. These are all elements that show that this relationship between the organization and the independent contractor is not of an employee or employer. So okay, now we'll go back to this example. So we know the characteristics of the employee. The employee is usually reporting to the organization, is usually paid on a biweekly basis. Taxes are usually taken out. They usually get benefits. The employee is usually given a uniform or given certain tools to use, and the tools are owned by the company, not the independent contractor. And if they're an employee, then the legal consequences are that the acts of the employee, if they're a tort within the scope of their employment, would flow up to the employer. So any liability would flow up. Now, the independent contractor, again, the characteristics we just talked about, it's a specific short time duration that the independent contractor will be doing that work for the organization, that taxes are not taken out, that they're paid in one lump sum, the contractor is bringing his or her own tools and has their own uniform. It's not an exclusive contract between the parties. We look at if there is a contract, what the contract actually says, and if it is an independent contractor, then there's no liability for the organization if a tort or an intentional tort or unintentional tort is committed. So what factors would it be dispositive for soccer referees or a trainer as to whether or not they're employees or they are independent contractors? And so that's something that you might want to think about. Does the soccer referee provide his or her own uniform? Does the organization tell the referee what dates and times and locations to be at? Is the soccer referee's opportunities with that organization year-round, or is it seasonal? Does the soccer referee need to provide their own insurance? Are their taxes being taken out, etc.? And with the student trainer, ask the same questions, or if the regular trainer, ask the same questions. So we look at how is the individual receiving instructions, how much control does the organization have over the potential employee or contractor, tools, materials, etc. So these are all how a court would determine whether or not someone is an employee or an independent contractor. And then we've got the Lang versus Silva case that helps to show a case of this type in action. So if you remember the facts of the case, Silva and Lang are jockeys, and they're in a race together, and Lang gets knocked off, and he sues. He sues both Silva and the horse racing outfit under the allegations, the argument that Silva was an employee of the facility. But the facility says no, he was an independent contractor, and the court looks at several aspects. I believe they said, well, that the racer has an agent, the jockey has an agent, the jockey is booked on a race-by-race basis, taxes are not taken out, he provides his own uniform, and because of that, he is not an employee, he's an independent contractor, and liability does not flow up to the horse racing organization. So some competitive strategies for sport managers when dealing with issues involving vicarious liability. It's important to know that we cannot control everything that happens with our facility or with our employer on a day-to-day basis. So it's virtually impossible to potentially avoid vicarious liability in all respects. However, it is important also to work with your employer in helping to create some sort of plan from a risk management or preventive law standpoint, so that you can address the potential liability that exists within your organization, whether it's hiring independent contractors or making sure that you hire people who are not going to potentially put the organization in a risk of being liable. So making sure that the organization is abiding by the duty of care for hiring qualified people for the position in which they claim they are. So doing some outside research, maybe working with a search firm, or doing background checks or checking other records. Then adequately supervising the employee to make sure that they are receiving the supervision that's required and getting the professional development. And then retention, if a reasonably prudent organization would discharge that employee under the based on the conduct, then again that duty of care is necessary. Now, in terms of independent contractors, you also need to make sure that the independent contractors are really meeting the criteria that's necessary to be an independent contractor, from a term of the contract, how they are paid, how they are supervised, who provides the tools, etc. So make sure that contractors provide a list of references, and make sure to check those references carefully so that you know that they are who they say they are. Now we move away from employees and independent contractors to talking about volunteers. So a volunteer is intuitively someone who assists an organization in some way, shape, or form, but is not given any compensation or money. Now, whether an organization is actually liable for the actions of their volunteer based on respondeat superior is not based on whether or not they're paid or not, but instead on how much control is exerted over their actions. So the more an organization treats that volunteer as an employee, the more likely that the volunteer will be treated as an employee, and therefore the torts that are made in the scope of their employment would then flow up to the organization despite them being a volunteer. So in terms of some competitive strategies, again, for anyone who's wants to be an asset to their organization, volunteers should be adequately screened and selected with the same amount of care that one would use for employees in similar types of positions. So again, that means working potentially with a search firm or an outside party, or doing background checks. The search firm could, in whether it's for employees or volunteers, could act as independent contractor to shift liability for employees that don't work out to that search firm, so that again there's a potential level of security to protect your organization. Care should be also particularly taken to screen volunteers who will be in some position of authority or be trusted with minors. So again, these are vulnerable populations, minors and someone with a disability. So you want to make sure that you take extra care for that, or anyone who might have the ability to act on behalf of the organization. And then finally, it talks about, the text talks about any potential liability for the actions of athletes. So it's interesting because, or student athletes or professional athletes. So it's interesting that generally speaking, the relationship between student athletes and the employer is not employee-employer. And that's based mostly on the aggressive lobbying of the NCAA to create the designation, the term student athlete, which really is a creation that never existed before the NCAA came along. But according to case law up to this point, athletes are not agents of the university and not employees. So if there's a fight on the court and someone's injured, even if the student athlete is acting within the scope of his or her employment, there's no liability potentially for the college, potentially. I'm sure there's exceptions exist, but that's the general rule. Now, vicarious liability is something that should not be imposed on the university for the actions of the student athletes. But one exception might be for the coaches or support staff who are not student athletes but still affiliated with the university. It seems logical to argue that the actions, any tort of a normal employee like Art Briles, who commits some sort of negligent supervision and retention, that would still flow to the university as a tort. So we kind of close by talking about a couple of case studies involving negligence. So I want you guys to take a look at these, and these will be the assignments that you need to do for this week. So I want you to look at these case studies and evaluate the potential claims based on negligence, negligent supervising, or vicarious liability, and you'll be talking about that in your assignment. And then also the second one, which is involving concussions in hockey and no contact hockey. So again, they deal with situations where the question becomes whether or not vicarious liability exists or any sort of negligent derivative exists. And with that being said, if you have any questions, again, feel free to reach out. Negligence and vicarious liability are not easy concepts, so it's perfectly logical and normal to have issues with that. So with that, I will bid you guys adieu and see you next time.